I was seated right across from the jury as they listened to closing arguments. All of them seemed to be listening intently. A couple of them glanced over at Karen Read, and one even closed his eyes as if he was concentrating on every last word of this 2-month-long trial. Karen Read returned through a sea of reporters to the courthouse to hear closing arguments in her second-degree murder trial.
You see, you're the only thing standing between Karen Read and the tyranny of injustice.
Defense attorney Alan Jackson told jurors Read is innocent of killing her boyfriend, Boston police officer John O'Keefe, that she is a victim framed as part of a cover-up, he said, which he described as a tall blue wall.
A wall that you can't scale. A wall that Karen Read certainly couldn't get over. A wall between us and them. A place you folks are not invited.
Seated in the courtroom with the O'Keefe family, members of the Albert and McCabe families. They're the ones, Jackson said, who killed O'Keefe in a fight and an attack by their dog named Chloe.
A push, a punch, a fall, pull Chloe off his arm, and now it's done.
Read listened as prosecutor Adam Lally played some of the angry voice messages she left for O'Keefe the night he died. Lally said Read's own words point to her, so does physical evidence like taillight fragments found at the scene. Lally said vulgar insults against Read, made by the lead investigator on the case, are inexcusable but not proof of a cover-up.
Why? Because it didn't happen. There is no conspiracy, there is no cover-up, there is no evidence of any of that.
Using a bingo-style selector, the court clerk randomly chose 2 jurors to serve as alternates. Earlier, another juror was dismissed for what the judge said were reasons personal to her. And with that, the judge sent the remaining 12 jurors behind closed doors to deliberate.
Hello, all you legal-minded friends. Let's look at the differences between opening statements and closing arguments. And we will look at examples from the Karen Read trial while we wait for the jury to return a verdict. At the beginning of the trial, opening statements are limited to outlining the facts, basically setting up the scene. Let's watch the prosecutor set the stage.
This is one of the 2 opportunities that I will get to address. The first of which right now, essentially what I'm going to attempt to do, and I know you heard over the course of the impanelment process a number of different witnesses that were listed out as far as potential witnesses in this case. So what my intent here is to provide as much of a roadmap as I can through those waters and help you to navigate sort of who these people are and what relation they have to this case. Let me start with John O'Keefe.
So the prosecutor went on in opening statements to talk about the trial and how it will unfold. He talked about the victim, John O'Keefe, and the day leading up to the tragic incident. He let us know the connection the accused, Karen Read, had with the victim, John O'Keefe, like when they started dating. Opening statements also get into what exhibits the jury will see and who they will hear testimony from and what relationship they have to the case. So he went through all the witnesses and what they will be expected to say. Now, what is important about this is that opening statements not only give a roadmap of how the trial will unfold, they also will give an introduction of the core disputes. Let's listen to an example of the prosecutor tell the jury what he expects some of the evidence will show. Now, I'm just going to play a clip.
I anticipate he'll opine that around 12:45 in the morning, when the vehicle was in front of the residence on Fairview, that for some perceptible period of time, that vehicle traveled over 60 feet in reverse at over approximately 24.2 miles per hour. Now, you'll hear testimony, as I said, from a number of different troopers, as well as from a number of different analysts from different labs. Included within that is Ms. Maureen Hartnett.
So that might have been a little hard to hear, but what he was saying is that the evidence will show Karen Read was in front of the property and reversed back at a high speed, and we later hear that, she's accused of running over her boyfriend, and he later was found unresponsive and passed away. So they say that we're going to hear that this happened at 12:45. Now, this will be a core dispute between the parties, and the defense will present evidence to disprove any disputed evidence during the trial. And in their opening statements, they will provide this roadmap as well. They will dispute what they don't believe has happened. So you get this kind of back and forth of competing facts and what the evidence will show. So opening statements are meant to persuade. They are not arguments. In closing arguments, the attorneys can persuade with the overall significance of the factual evidence, and they are allowed to use hypothetical analogies to make their points. Let's hear an example of this in closing by the defense. Now, I will play a longer clip that disputes one of the merits that the prosecutor had said that we heard in opening, and I'll also play a clip that gives a hypothetical situation. So let's watch that, as I think it's a good example of the two.
That brings up another difficulty for the Commonwealth, and that's their star witness, Jennifer McCabe. You'll recall that Jennifer McCabe claimed that she was looking out the door, staring at that SUV over and over and over again from 12:29 to 12:50. She was very specific about that time frame. But we know that the SUV was gone from 34 Fairview by about 12:30. Had to be in order to connect to the Wi-Fi at 12:36. So unequivocally, Jennifer McCabe was lying about watching that SUV, and it makes you wonder why. And to add to that deceit, she was also blatantly lying about the calls to John's phone. You remember that colloquy back and forth. She said that every single one of those calls to John's phone during that time was a butt dial. How are those lies connected? And why are they connected? Jennifer McCabe knows. Was she butt dialing John over and over? Or was someone looking for John's phone? But there are more odd and unexplained things. After a night of drinking and hanging out and partying, after being together for the entire day, at 2:22 a.m., Brian Albert decides to call Brian Higgins. That call was missed, but 17 seconds later, Higgins calls Brian back, and they speak for 22 seconds. Now that call is odd and suspicious enough, in and of itself, the fact that the call was made. But what's even more incriminating is that both men, both of them, lied about the calls happening. They both claim astonishingly that those calls are, you probably say it with me, they're butt dials. Amazing. But Albert and Higgins take it a step further. Not only did they claim that they were making calls as butt dials, but they were answering calls as butt dials. And Higgins seemed awfully defensive about that call, didn't he? Remember on cross-examination when I was asking him, can you have a conversation in 22 seconds? He unequivocally said, no, that's impossible. It's not reasonable. You can't do it. Well, let's test that out. Hey, did you make it over to Canton? Yep. Haven't been any calls. Nobody knows a thing. All right, don't talk to anybody until we talk again. Okay, fine. And by the way, come back over. I need help moving something heavy. How long did that take? 15 seconds? Maybe? But the odd behavior isn't done yet.
So there's a big difference in closing. Parties can comment on the credibility of the witnesses and how they believe the pieces of the puzzle fit together. So the jury will have a reason to decide in their favor. So the main difference in opening statements is that the parties are restricted to stating what the evidence will show and who will be testifying. In closing arguments, the parties are free to argue the merits, which are the points that deserve attention to establish who could be held responsible. After closing arguments, in this case, the court allowed each side only 1 hour to give their closing statements, so they really had to focus on the merits they wanted the jury to consider. Now I want to illustrate something else. So in this next video, we're going to listen to what the prosecutor said in closing.
All right, Mr. Lally.
Thank you, Your Honor. I hit him, I hit him, I hit him, I hit him. Those are the words of the defendant. 4 times. You heard testimony from 4 different witnesses who overheard and observed those statements from the defendant on January 29th, 2022.
So, I was really surprised with that, because if you've been watching the trial, Karen Read did not say, I hit him 4 times. I don't even know if she said it 3 times, but that's what the evidence they brought out said she said. So why would he say 4 times now? It's very confusing. But did she even really say, I hit him? If you want to know what she really said, you're going to have to watch my video. It's on the screen, and I'll leave a link below. When closing statements are finished, the court will give instructions to the jury that whatever the defense and the prosecutor say is not evidence. They need to use their own common sense when looking at the evidence. And this is important because we need to do that too, even though we're not part of the jury. But you never know, one day we might be. So let's listen to the judge on this point.
You must not be swayed by personal likes or dislikes. Your deliberations are no place for emotion or sympathy, passion or prejudice. The Commonwealth and Karen Read have a right to have the case judged by fair and impartial jurors. All parties who come before the court stand as equals before you. Therefore, your verdicts must be based on the law as I've given it to you, and on the evidence and the facts that you find, and nothing else. You cannot allow yourselves to be influenced by any personal feelings you may have about the nature of the crimes with which Ms. Read has been charged, or the consequences of your verdict. Just the cool, reflective, and impartial sifting of the evidence so that here in this courtroom, justice may be done. Now, your focus is on the evidence. I am the judge of the law. My job is to teach you the law that you must follow in this case. However, I have no opinion about how you decide this case. You should not consider anything I have said or done during the trial as reflecting any opinion by me about how you should decide this case. If you believe that I have an opinion about the facts of this case, you must disregard it. You must decide this case based solely on the evaluation of the evidence. Now, the arguments of the lawyers are not evidence. They are not witnesses. If a lawyer, during argument, made a mistake in summarizing the evidence or argued something not supported by the evidence, you must disregard it. It is the jury's collective memory of the evidence that controls the matter. Lawyers' objections are a proper part of the court's procedure and are not part of the evidence. So don't hold it against the lawyers or their client if they made objections, motions, or other requests. They are simply doing their job during a trial.
Well, I hope this gives you a better understanding of what the differences of opening statements and closing arguments are. I have left links below if you want to watch them in full. We are now on verdict watch. So the jury is going through all the evidence, the testimony, the exhibits, and they will come to their own conclusion. And the judge will obviously give them to the law to, balance everything with. So go grab a coffee as we are on verdict watch. I will update this video with a comment when we get a verdict, and I will also put it in my community posts. So I will leave you with our playlist if you want to know more about this case. There are so many what, when, why, how, where, and who questions still left unanswered. In my view, the prosecution has not met their burden of proof. And that would mean, if you think the same way, you would have voted not guilty. I'm Karen Cole from Legal Minded Friends. What's your thoughts? By leaving a comment, you may help someone else that will read your comment. And of course, I love to read all comments as they are valued, and together we can be more informed. And this information may help you or someone you know. In the meantime, on this channel, you'll find a variety of playlists to suit every curiosity about the justice system. And we provide you with a visual to information and the process. Going through a legal worry is devastating, and the Who Knew and Why Me playlists are designed to help you or someone you know. So please like this video if you like this kind of content. Hit the subscribe button and the notification bell if you want to be notified when I'm going live or upload another video. I'm Karen Cole from Legal Minded Friends. Information is power, meaning if you know something, you can make decisions that are right for you.